My name is Ray Kulski. I'm 47 years old, and I've lived in the same house on Birchwood Lane for 11 years. It's a corner lot in a mid-sized suburb in the southeast. Not a fancy neighborhood, not a rough one. The kind of neighborhood where people wave when they drive past, where kids ride bikes in the street in summer, where somebody always brings a dish to a block party even if they're not sure they're actually invited. Comfortable. Ordinary. The kind of place where nothing dramatic is supposed to happen. My house was built in 1987. It's a 3-bedroom brick ranch with a detached garage that sits behind the house, accessible from a concrete driveway that runs along the left side of the property from the street all the way back to the garage door. That driveway is about 90 feet long and 12 feet wide. It's been there since the house was built. It is, to put it simply, how I get my car into my garage. The property to my left, the one that shares my left property line, was vacant for about 2 years after the previous owners, a retired couple named the Guffolds, moved to Florida to be near their grandchildren. Nice people. We exchanged Christmas cards for the first couple years after they left. The house sat on the market for a while because it needed some work, and then finally sold about 3 years ago. That's when Sandra Kumbler moved in. Sandra was in her late 40s when she moved in, recently divorced, one adult son who visited occasionally. She had a small insurance agency she ran out of a home office, which meant she was home most of the day. She drove a silver sedan and kept her yard reasonably neat, and in the early days, she seemed perfectly fine. We exchanged the standard new neighbor pleasantries. I helped her carry a piece of furniture when her son wasn't around to do it. Runner, my wife, brought over a casserole the first week, like she does with new neighbors. Everything was normal for about 4 months. The first sign of what was coming was small enough that I almost didn't register it. Sandra mentioned, casually, while we were both getting our mail one afternoon, that she was thinking about adding a garage to her property. Her house didn't have one. She said she wanted covered parking and some storage space. I said that sounded like a good project and didn't think anything more about it. A few weeks later, she mentioned it again, and this time she said she'd been looking at her property survey and talking to a contractor, and that she was thinking about putting the garage on the left side of her house, which was the side closest to my property line. I said that made sense since her house sat to the right of her lot. She said yes, and that it would be close to the property line, but within the allowable setback. I nodded and said, as long as everything was up to code, I was sure it would be fine. What I didn't do at that point, and this is the thing I've turned over in my mind 100 times since, was go pull my own survey map and actually look at what she was describing. I assumed she knew where her property line was. I assumed a contractor building near a property line would verify the survey. I assumed the city building permit process would catch any encroachment before construction started. I assumed a lot of things. Every one of them was wrong. The construction begins. Construction started on a Monday in early spring, about 8 months after Sandra moved in. I was at work when they broke ground. I'm a production manager at a commercial printing facility, work 8 to 5, Monday through Friday. Runner works part-time at a dental office and was home by 2 that day. She texted me around 3 saying there was a construction crew at Sandra's and it looked like they were pouring a foundation slab. I texted back saying that was probably the garage she'd mentioned. Runner texted back, it looks really close to your driveway. I told her I'd take a look when I got home. When I pulled into my driveway that evening, I understood immediately what Runner meant. The foundation forms, the wooden frames that hold the concrete in place while it cures, were sitting right at the edge of my driveway, not 6 inches from it, not a foot from it, right at the edge. In fact, when I got out of my car and walked over to look more carefully, I saw that the forms on the near side were actually touching the concrete of my driveway. I stood there for a minute just looking at it. Then I went inside and told Runner I needed to find my survey documents. The survey documents. I keep my important documents organized in a filing cabinet in my home office. Runner sometimes mocks me for being overly organized about paperwork, but moments like this are exactly why I do it. I found the original survey map from when I purchased the house within about 4 minutes. I spread it on the kitchen table and looked at it carefully. The property line between my lot and Sandra's lot ran, according to the survey, approximately 18 inches to the left of my driveway's left edge. 18 inches. That was the gap between my driveway and her legal property line. The building setback requirements for our municipality, I looked these up online that evening, required any structure to be set back at least 5 feet from a property line. Sandra's foundation forms were sitting at the edge of my driveway. My driveway was 18 inches from the property line. The foundation forms were therefore approximately 18 inches from the property line. Not 5 feet, 18 inches. And the forms were touching my driveway. I went to bed that night telling myself there had to be a mistake. A contractor makes a mistake, the city catches it during inspection, they move the forms, they rupkey the slab in the right place. These things happen. I would talk to Sandra in the morning. The conversation with Sandra. I knocked on Sandra's door the next morning before I left for work. She answered in her bathrobe, which told me I'd gotten there early enough to catch her before the crew arrived. I told her I'd looked at my survey map, and I was concerned that the foundation placement was too close to the property line and was actually up against my driveway. Sandra frowned and said her contractor had measured everything, and it was all within the setback requirements. I said my survey showed the property line was only 18 inches from my driveway edge, which would put the structure well inside the 5-foot setback. She said her contractor had a different measurement. I said I'd like to see that measurement. She said she'd ask him about it and let me know. I said thank you and went to work. She never let me know. The crew poured the slab that day. The slab, the walls, and the silence. I called the city building department that afternoon from my office. I told them I had a concern about a structure being built adjacent to my property that I believed was not in compliance with setback requirements. The woman I spoke to was polite and told me I could file a complaint, which would result in an inspector being sent out to verify compliance before any further work was approved. I filed the complaint over the phone, gave my name and address and Sandra's address, and was told an inspector would be out within 5 business days. 5 business days, that's a week, essentially, in practical terms. Sandra's contractor poured the slab Tuesday, framed the walls Wednesday and Thursday. By Friday afternoon, when the building inspector finally showed up, the garage was framed to full wall height. The inspector, I watched this happen from my driveway, spent about 20 minutes on the property with a measuring tape and a clipboard. He spoke with Sandra, he made some notes, he got in his truck and left. I called the building department the following Monday and asked for the status of my complaint. The woman who answered told me the inspection had found the structure to be within setback requirements and no violation had been noted. I said that wasn't possible given my survey map. She said the inspector had measured from the property line and found compliance. I asked which property line he had measured from. She said she couldn't tell me that from the notes she had. I thanked her and hung up and sat at my desk for a moment thinking about what to do next. Then I called my neighbor Frank Gullum across the street, who I knew had recently dealt with a property dispute of his own, and asked him if he knew a good property attorney in the area. He gave me a name, Muckers Webb, Real Estate and Property Law. I called Muckers Webb that afternoon. Marcus Webb. Muckers Webb had been practicing property law in our county for 18 years. He was direct, methodical, and refreshingly free of drama. When I described the situation, showed him my survey map over a shared screen during a video call, he looked at the numbers for about 30 seconds and then said, "Okay, first thing we need is an independent survey." He explained that my original survey, while likely accurate, was 11 years old. Property dispute cases involving encroachment are much stronger when backed by a current, independent survey conducted by a licensed surveyor specifically hired to determine the exact boundary. He said the building department's inspection measurement might have been taken from a different reference point than my survey used, or might have been conducted incorrectly, or might reflect an error in the city's own records. An independent survey would tell us what we were actually dealing with. He gave me the name of a surveying firm he'd worked with before. I called them that afternoon and scheduled a survey for the following week. The survey took about 4 hours, 2 surveyors on my property and the adjacent line, with professional equipment referencing county records and physical markers. At the end of it, one of the surveyors came and found me and showed me the results on his tablet. My original survey had been accurate. The property line was exactly where it had always been. Sandra's garage slab, now with walls framed and a roof being put on, was encroaching on my property by approximately 7 inches along a stretch of about 32 feet. 7 inches, more than 3 feet inside the required 5-foot setback from the property line. And the corner of the slab's footing, the foundation itself, was physically touching my driveway concrete. The surveyor filed his report with the county. I sent a copy to Marcus Webb. Marcus read it and called me the next day. He said, "Ray, this is a clear encroachment. The structure is on your property. We have grounds to demand its removal." The letter and Sandra's response. Marcus drafted a formal encroachment notice and sent it to Sandra by certified mail. It laid out the findings of the independent survey, stated clearly that her garage was encroaching on my property by 7 inches over 32 feet, noted that the foundation was in contact with my driveway concrete, and demanded that she cease all further construction immediately and present a plan for remediation, meaning bringing the structure into compliance or removing it, within 30 days. I know Sandra received the letter because I was home the morning the mail carrier delivered it, and I saw her sign for it at her door. She did not respond within 30 days. She did not respond at all. What she did do in those 30 days was finish the garage. The roof went on. The garage door was installed. She had the exterior painted. By the end of those 30 days, the garage was complete. It was a fully built, finished structure sitting 7 inches over my property line with its foundation touching my driveway. Marcus sent a second letter at the 30-day mark. This one was more direct. It stated that her failure to respond constituted a rejection of the opportunity to resolve the matter voluntarily, that we would now be seeking judicial relief, and that the costs of any court-ordered removal would be her responsibility. Sandra's response to this second letter came 4 days later, not from Sandra herself, but from an attorney. His name was Philip Garland, and his letter was about 2 pages of legal language that boiled down to this. Sandra disputed the encroachment findings, disputed the validity of my survey, claimed her contractor had verified all setback requirements prior to construction, and asserted that my driveway may itself have been improperly constructed outside of my property's boundaries. That last part, the claim that my driveway might be the problem, made Marcus actually laugh out loud when he read it to me over the phone. He said, "Philip Garland, I've dealt with him before. He writes a lot of confident letters. They don't always hold up." I asked Marcus what our next step was. He said, "We filing suit." Marcus filed suit in county civil court seeking a mandatory injunction, a court order requiring Sandra to remove the encroaching portion of her garage, along with damages for the cost of the survey, my legal fees, and compensation for the ongoing interference with my use and enjoyment of my property. The case was assigned to a judge, and a hearing date was set for approximately 4 months out. 4 months is not a long time in court terms, but it's a long time to live next door to someone you're suing while that person's garage is sitting on your property. Those 4 months were uncomfortable, to put it mildly. Sandra stopped waving when she drove past. Her son, when he visited, gave me flat looks from the driveway. There were a couple of HOA meetings during that period. We were both in the same HOA, which had its own layer of complication, where the tension was noticeable enough that other neighbors started choosing seats based on which side of the room they wanted to be on. The HOA, to their credit, largely stayed out of it. The HOA president at the time A calm retired engineer named Douglas Park told me privately that he'd looked at the survey results and the situation was clear to him, but that it was a civil matter between property owners and the HOA wasn't in a position to get involved in litigation between members. I respected that. One thing that happened during those 4 months that I want to mention: Sandra approached Renee at the grocery store one afternoon. Renee came home and told me about it. Sandra had asked Renee if I would consider settling the matter by accepting an easement, a legal arrangement that would acknowledge her garage was encroaching but would grant her the right to maintain it in its current position in exchange for a payment. Marcus had actually mentioned this as a possible resolution when we first filed. An easement payment in cases like this can range from a few $1,000s to significantly more depending on the nature and impact of the encroachment. It's not an unreasonable resolution in some cases. The problem in my case was specific and serious. My driveway, the garage's foundation, was in contact with my driveway concrete. Over time, through freeze-thaw cycles, through the natural settling of foundations, through the pressure of a finished structure sitting against concrete it was never supposed to touch, that contact could cause my driveway to crack and shift and ultimately require repair or replacement. A driveway 90 feet long and 12 feet wide, full replacement, runs between $8,000 and $15,000 depending on concrete prices. I was not interested in accepting an easement that left that problem sitting against my property indefinitely. I told Renee to tell Sandra politely that she should have her attorney call Marcus. The attorneys talked, no settlement was reached, we went to court. The hearing. The court hearing lasted most of a morning. Philip Garland, Sandra's attorney, made several arguments. The main ones were that the independent survey was flawed, that the contractor's measurements should be given equal weight, and that ordering removal of a completed structure was an extreme remedy that the court should be reluctant to impose. Marcus countered each argument methodically. On the survey, the surveyor was licensed, had 31 years of experience, had submitted his methodology and findings to the court, and his results were consistent with my original 11-year-old survey. On the contractor's measurements, no formal survey had been conducted by or for Sandra prior to construction, and no licensed surveyor had certified her setback compliance. On the remedy, the law in our state regarding encroachment was clear. A property owner whose land is encroached upon is entitled to have that encroachment removed. The fact that Sandra had built a completed structure rather than stopping when she received the first complaint letter was her choice, not a reason to allow the encroachment to continue. Marcus also made a point that I thought was particularly effective. He put up on the screen a photograph of the corner of Sandra's garage foundation in contact with my driveway concrete. He explained the structural implications, the potential for damage to my driveway as the two concrete elements moved against each other over time. He had a structural engineer's brief written statement supporting this analysis. The judge asked Philip Garland if there was any dispute about the physical contact between the foundation and the driveway. Philip Garland said he couldn't dispute the photograph, but that any damage to the driveway could be addressed through future compensation if and when it occurred. The judge said, "So your client's position is that Mr. Kowalski should wait for his driveway to be damaged and then seek compensation rather than having the encroachment removed now." Philip Garland said that was one way to characterize it. The judge said she had another way to characterize it and moved on. The hearing ended. The judge said she would issue her ruling within 2 weeks. The ruling came in 11 days. The ruling. I was at work when Marcus called. I stepped outside to take it. He said, "Ray, we got everything." The judge had ruled in my favor on all counts. Her order required Sandra to remove the encroaching portion of her garage, specifically to relocate the structure so that it complied fully with the 5-foot setback requirement from the property line within 60 days. The order also awarded me the cost of the independent survey, my legal fees through the date of the ruling, and an additional amount for what the judge characterized as the ongoing interference with my property rights caused by Sandra's failure to respond to the original encroachment notice and her decision to complete construction rather than pause. Total award, excluding the removal itself, just over $14,000. Marcus told me he'd send the order to Philip Garland that afternoon and that the 60-day clock would start running from the date of service. I thanked him, went back inside, and tried to focus on work for the rest of the day. I mostly failed. I kept looking at my phone, expecting something, a call from Sandra, a message from her attorney, something, but nothing came that day. Nothing came for the first 2 weeks of the 60-day period either. Then I got a call from Marcus saying that Philip Garland had contacted him to say Sandra intended to appeal the ruling. The appeal attempt, and what HAPPNED next? An appeal, Marcus explained, would not automatically stay the removal order. Sandra would need to request a stay, a court order pausing the requirement to comply while the appeal was heard, and would need to demonstrate that the appeal had merit and that the harm to her from complying would outweigh the harm to me from the delay. Philip Garland filed a motion for a stay. Marcus opposed it. The same judge reviewed the motion. She denied it. The stay was denied. The 60-day clock kept running. Sandra's appeal was filed, but it did not pause her obligation to comply with the removal order. At day 45 of 60, Marcus contacted Philip Garland asking for a compliance timeline. Philip said Sandra was exploring options. At day 58, with 2 days left, Marcus filed a motion for enforcement, putting the court on notice that we expected the deadline to pass without compliance and requesting that the court authorize us to retain a contractor to perform the removal at Sandra's expense. The deadline passed, nothing happened. Sandra's garage still sat 7 inches over my property line with its foundation touching my driveway. Marcus went back to court. 2 weeks later, the judge issued an enforcement order authorizing me to hire a licensed contractor to perform the removal and to bill the costs to Sandra, on top of the existing judgment against her. Marcus called contractors, I called contractors, we got 3 bids. And then I called the one I chose and scheduled a date. The morning of. I took the day off work. I was up at 5:30, made coffee, sat at the kitchen table for a while in the quiet. Renee was up too. She made breakfast, eggs and toast, nothing special, and we ate mostly in silence, not uncomfortable silence. The silence of 2 people who have been through something together and are watching it end. The contractor arrived at 7:45. His name was Carter Blythe, and he ran a small excavation and demolition company. He'd done work like this before, partial structure removal for encroachment cases, and he was straightforward and professional about it. He had 2 workers with him and the equipment necessary to do the job cleanly. I had notified Sandra, through Marcus, of the enforcement date. She had been formally served with the enforcement order. She knew this was coming. When Carter and his crew pulled into my driveway, I saw Sandra's curtain move in the front window. She was in there. I carried my coffee mug to the front porch, pulled up a chair, and sat down. Carter walked over to me first, and we went over the specifics. The removal would focus on the encroaching section, the portion of the garage that crossed the property line. The structure would need to be partially dismantled to allow the foundation to be properly separated from my driveway. The garage, when it was done, would not be a complete structure anymore. It would be Sandra's problem to rebuild it in the correct location. I told Carter to proceed. He nodded and walked back to his crew. The equipment fired up. The sound was loud in the quiet morning neighborhood. Heads appeared at windows up and down the block. Sandra came out onto her porch. While she watched, she stood at the edge of her porch in a gray cardigan with her arms crossed. She was maybe 40 feet from me across the property line. I could see her face clearly. Carter's crew began at the roofline first, removing the roof section over the encroaching portion carefully, piece by piece, then the wall framing, then the exterior boards. Sandra watched all of it. She didn't scream when the walls started coming down. I want to be accurate here. She didn't make any dramatic sounds. What she did was go very still in the way that people go still when they're holding something in that's too big to let out in a normal setting. At some point, her son showed up, pulled into her driveway in a hurry, must have called her when he heard about it. He stood beside her for a while and they spoke quietly. He put his arm around her shoulders. I felt something watching that, not satisfaction, not victory, something closer to sadness, honestly, for how it had all gotten to this point. She had built something, and it had to come down because she put it in the wrong place and refused every opportunity to fix it. That was her series of choices, not mine, but I'm not made of stone. Watching someone's thing get demolished isn't fun, even when it's the right outcome. A neighbor from down the street, a woman named Joyce Crandall, who I'd known for years, came and stood at the edge of my front yard for a minute. She didn't say anything to me, just stood there watching for a moment and then walked away. I think she was trying to process what she was seeing. Most of us are not used to watching legal enforcement actions happen in real time. Carter and his crew worked for about 4 hours. By early afternoon, the encroaching section was down. The foundation was cut cleanly at the property line. My driveway was intact. They'd been careful about it. The corner where the foundation had touched my driveway concrete was now clean and clear. Carter came and found me when they were done and walked me through the work. He showed me the property line, the cut, the clearance, everything exactly as ordered. I shook his hand and thanked him. He said, "You okay?" I thought about it for a second and then said yes. He nodded and started loading his equipment. End of part 1. Sandra was still on her porch when Carter's truck pulled out of my driveway. I stood at the edge of my property for a moment, not looking at her, just looking at the space where the encroaching section of her garage had been. The exposed framing was raw and rough. Her garage was now open on one side, incomplete, waiting for whatever came next. I picked up my empty coffee mug from the porch chair and went inside. Renee was in the kitchen. She looked at me when I came in, and I looked back at her, and neither of us said anything for a moment. Then she said, "Dinner." I said, "Yeah, dinner." What I didn't know yet, what I found out over the following weeks, was that the story wasn't quite over. Sandra's appeal was still pending, and the appeal was going to produce something none of us expected. Part 2. The appeal decision. Marcus called me 3 weeks after the removal with news I hadn't been anticipating. Sandra's appeal, the one that had been filed but hadn't stopped the removal, had been decided. The appellate court had reviewed the case and issued a brief opinion affirming the lower court's ruling in full. Not modified, not sent back for reconsideration. Affirmed every element: the encroachment finding, the removal order, the damages award. That part wasn't the surprise. Marcus had expected the appeal to fail, and it had. The surprise was a supplemental ruling the appellate court issued alongside its affirmation. The appellate judges, reviewing the record, had taken note of something that neither Marcus nor I had specifically pushed for: the timeline. Specifically, the fact that Sandra had been given notice of the encroachment before construction was complete, had received a certified letter demanding she cease construction, had failed to respond, had allowed construction to finish, and had then refused to engage with resolution efforts for months before any litigation was filed. The appellate court characterized this conduct as demonstrating a willful disregard for the property rights of the adjacent landowner, and held that the lower court's damages award was not only appropriate, but should be supplemented to account for the full cost of the removal that had been performed. They remanded the case back to the lower court solely for the purpose of calculating and entering that additional amount. Marcus explained what this meant practically. The cost of Carter Blythe's work, which had run to just over $9,000, would now be added to the judgment against Sandra. Combined with the existing judgment, Sandra owed me approximately $23,000. I sat with that number for a minute. Marcus said this happened because she didn't stop when she had the chance. Every time she had an off-ramp and didn't take it, the exposure got bigger. What the NEIGHBORS saw. I live in the same neighborhood. I've lived in for 11 years. My neighbors watched all of this happen. That's just the reality of living in close proximity to other people. Disputes don't stay private the way you'd want them to. Joyce Crandall, the woman who'd stood at my yard the morning of the removal, came over a few days afterward with a plate of cookies. She sat at my kitchen table with me and Renee for about half an hour. She told me that a lot of people on the block had been watching the situation for a while and that most of them understood what had happened but hadn't felt it was their place to get involved. She said something I've thought about since. She said, "The thing is, Ray, everybody here knows what Sandra did was wrong. She built over your driveway, but people don't know how to handle it when a neighbor does something wrong and won't admit it. So they just watch and hope it works out." I said I understood that. I didn't say it without some bitterness, honestly, because there were moments during those 14 months when I'd have appreciated knowing people saw clearly what was happening. But I understood it. Douglas Park, the HOA president, called me a week after the appellate ruling. He was careful about what he said, HOA president, aware of his role, not trying to take sides. But he told me he wanted me to know that he and the board had reviewed the situation thoroughly and that the HOA would be updating its construction notification protocols. Going forward, any member planning construction within 8 feet of a property line would be required to submit a copy of a current professional survey to the HOA along with their building permit before breaking ground. He said this new protocol was directly inspired by what had happened on Birchwood Lane. I told him that was a reasonable response and that I appreciated it. Sandra's situation. I want to tell you what happened to Sandra because I think it matters for the completeness of this story and because I don't want to leave you with a picture that's simpler than reality. Sandra did not take any of this easily. I know that from what I observed and from what a few mutual acquaintances told me in the months that followed. The removal left her garage in a state that required significant additional work to make it functional and weatherproof. The exposed side where the encroaching section had been removed needed to be properly closed in new framing, new exterior boards, a new wall, properly sealed against weather. She couldn't use the garage at all until that work was done. She had to hire a contractor to finish it, this time with a proper survey and within the correct setback. That cost her money on top of the judgment. The judgment itself, the $23,000, she contested through every available legal channel. Marcus handled the post-remand hearing on the additional damages, and the lower court entered the full supplemental amount as ordered. Sandra's attorney filed a motion to reconsider. It was denied. As far as I know, as of the time I'm telling you this, the judgment has been partially satisfied. Marcus has been working through the collection process, which is its own slow grind. These things take time. What I know for certain is that Sandra sold her house about 8 months after the removal. I saw the for sale sign go up one morning and felt a complicated mix of things that I won't try to fully describe. She moved out on a Thursday in late autumn. I saw the moving truck from my kitchen window. I didn't go outside. What about the HOA? You might be wondering, as some people have asked me when I've told this story, why the HOA wasn't more involved in stopping this before it got to where it did. The honest answer is that the HOA's enforcement authority is generally over things like fence heights, lawn maintenance, exterior paint colors, and similar visible condition issues. Property line disputes are civil matters between landowners, and HOAs generally, and often wisely, avoid inserting themselves into those situations unless a clear violation of HOA rules is also involved. Sandra's garage, as built, did comply with certain HOA aesthetic guidelines. The style matched the neighborhood. The exterior color was appropriate. The issue was solely the property line encroachment, which was a matter between her and me, not her and the HOA. I don't entirely fault the HOA for staying on the sidelines. Douglas Park's decision to update the construction notification protocol was, I thought, the right organizational response, learning from what happened to make the system better going forward without trying to retroactively manage a legal dispute between two members. What I do think is that the building department failed in its inspection process. The inspector who came out when I filed my initial complaint measured incorrectly or from the wrong reference point. If that inspection had caught the setback violation when the slab was still the only thing poured, the whole thing could have been stopped right there. A slab can be broken up and repaired relatively cheaply. A finished garage with a roof and a door is a different matter. I filed a formal complaint with the city building department about the inspection after the court case concluded. I have no idea what happened to that complaint internally, but I filed it. The driveway inspection. One of the things I was most concerned about throughout this process was the condition of my driveway after the garage foundation had been sitting against it for months. When Carter's crew did the removal, they were careful, but the question was whether any damage had already occurred before they got there. I had a concrete contractor come out 2 weeks after the removal and do a full inspection of the driveway. He went section by section with a careful eye, looking for cracks, shifts, any sign that the pressure from the adjacent foundation had caused movement. His assessment was that the driveway was in good condition. The contact between Sandra's foundation and my driveway concrete had been relatively brief in structural terms, less than a year, and no significant damage had occurred. He found one very small crack near the corner where the contact had been that he said was minor and could be sealed preventatively. He sealed it, cost me $80. I stood at the end of my driveway after he left and just looked at it for a minute. 90 feet of concrete, intact, exactly as it should be. The same driveway I'd pulled into every evening for 11 years. The same concrete Renee and I had pressure washed together in the spring, that the neighborhood kids had drawn chalk pictures on, that my daughter's first bike had wobbled down before she found her balance. It was just a driveway, but it was mine, and it was right, and that meant something. What I wish I'd done differently. I've been asked this question more than once, and I think about it honestly. There are a few things. I wish I had pulled my own survey map and walked the property line the moment Sandra mentioned she was building a garage on that side of her property. Before construction, before plans were drawn. Just walked it with my map in hand and had a clear conversation about exactly where the property line was. That might have prevented everything. I wish I had pushed the building department harder after that first inspection came back clean. I accepted their answer too easily. I should have gone in person, asked to see the inspection notes, pushed for a re-inspection. I had an independent survey at that point showing a violation. I should have been louder about it. I wish I had hired Marcus Webb earlier. From the moment the slab was poured in the wrong location, rather than waiting to see if Sandra would fix it voluntarily. I gave her more benefit of the doubt than she deserved, and that probably extended the whole process by 2 or 3 months. What I don't wish is that I'd handled the human side of it differently. I was never hostile to Sandra. I never shouted, never made it personal in ways it didn't need to be. I tried every reasonable avenue for resolution before going to court. That matters to me. It matters that when people look back at this situation, the record shows that I did it the right way. The lesson about property lines. Here's what I want to say to anyone watching this who owns property. Know your property lines, not approximately, not based on where you think the fence is or where the old owner told you. Get your survey, understand your deed, walk your boundaries. This is basic ownership responsibility, and most people skip it entirely because it seems like a bureaucratic detail that doesn't matter in daily life. It matters the moment someone builds something next to your land. The second thing is this: don't assume that official processes will catch problems automatically. The building department inspector failed in my case. The HOA didn't have tools to catch it. The burden was on me to document the problem and push it through the right channels. That's not fun and it's not fair, but it's the reality. And the third thing, maybe the most important, is to act early. The moment I saw those foundation forms touching my driveway, I should have been in Marcus Webb's office the next day with my survey in hand. Every day you wait after an encroachment is poured in concrete is a day the other side is building a more complicated removal problem. Sandra spent approximately $40,000 total on this situation, between her legal fees, the removal costs that became part of the judgment, the additional construction to fix her garage afterward, and the judgment itself. Her garage, properly built 3 feet to the right of where she put it, would have cost her maybe $18,000. She paid more than twice what it should have cost because she didn't listen when she had the chance. The house today. I still live on Birchwood Lane. The house is the same house. The driveway is the same driveway. My garage sits at the end of it, detached, and exactly where it's always been. A new family moved into Sandra's house about a month after she sold it. Young couple, 2 small kids, dog that immediately became best friends with my neighbor Frank Gilliam's dog across the street. They introduced themselves the week they moved in. Brought over a bottle of wine. Seemed like good people. Their garage, Sandra's garage, properly rebuilt after the removal, sits entirely on their property with the correct setback maintained. I measured it myself when they were having it refinished shortly after they moved in. Not because I suspected a problem, just because I know how to do that now and I will always know. The new neighbor's name is Marco. He asked me once, early on, if I knew anything about the previous owner and why she moved. I thought about how to answer that for a second. I told him she had some property line issues that got complicated. He nodded and didn't push further. Some stories you tell in full, and some stories you just let sit. This one, though, I wanted to tell in full, because it's not really about a garage. It's about what happens when someone decides that what they want matters more than where the line is, and about what happens when you hold that line anyway, even when it takes 14 months and costs you real money and makes your neighborhood uncomfortable, and ends with a bulldozer in your driveway on a Tuesday morning while your neighbor watches from her porch. You hold the line because it's yours, because it was always yours, because that's what the deed says, and that's what the court confirmed, and that's what the concrete proves. My name is on that deed. It always was, and my driveway is exactly where it always was.